We're going to be talking about legal issues that affect Native women and families here in Oklahoma and at the federal level. In particular, some of the recent legislative and federal policies that have come up here in Indian country in the last year. We've been quite busy. So I was wondering if you could talk a little bit about some of the changes and developments in the Indian Child Welfare Act and also VIWA, Violence Against Women.
Okay. So from the legislative perspective, we have new federal legislation that's going to expand tribes' abilities to maintain safety in tribal communities. Before the passage of the new Violence Against Women Act reauthorization, tribes didn't have any prosecutorial authority over non-Indian offenders who committed domestic violence crimes against American Indian women. American Indian women are 2.5 times more likely than any other population in the demographic to be victims of domestic violence, and the vast majority of the perpetrators in those cases are non-Indian. So the way that the jurisdictional schematic was set up before this new reauthorization, tribes did not have authority to criminally prosecute non-Indians. So the new legislation allows tribes to prosecute non-Indians for domestic violence crimes committed against intimate partners, and it will expand the authority that tribes are able to exercise in keeping their community safe. It's not a blanket authorization. It will be a pilot project that starts on a very limited basis, but it is a slow start towards trying to address those issues in Indian country and represents an expansion of the federal government's recognition of tribe sovereignty to be able to do what they need to do to keep their community safe. From the Indian child welfare perspective, we had a very interesting case decided by the United States Supreme Court that got quite a bit of media attention, and it was a very concerning opinion as proffered by the Supreme Court. It could have been much worse. The Supreme Court did recognize the Indian Child Welfare Act as the law of the land. They upheld its constitutionality, but the way they applied it to the facts of the case, it was very concerning for American Indian communities, in particular American Indian families who are given more protection under the federal legislation when there is an attempt to remove an American Indian child from an American Indian family. So the way that the case shook out at the Supreme Court was not as Indian country would have hoped, but at the end of the day they did uphold the Indian Child Welfare Act, and that was a win in some form or fashion. That opinion was extremely infuriating for a lot of us who work in Indian country. The thing I noticed, the very first thing I noticed whenever the opinion was released, is that the very first sentence of the opinion points out the child in question's blood quantum. It's almost as if the Supreme Court was wrestling with the issue of why do we even have to deal with this federal legislation that protects American Indian children, because in this case this child is only X% American Indian, and it was a precursor. It gave us a hint as to what the Supreme Court was going to do with the facts of that case, but it really did highlight the ignorance and the intolerance for American Indian issues at that level, and it's very concerning.
Well, which is what's interesting about that is that blood quantum is not an issue for the tribe in question, right, that child was a member of. So, and even more so, blood quantum is not traditionally something that Native people are concerned with. I mean, that's not our system. That's a system that was imposed upon us.
Well, Doe, for that wonderful discussion about legal issues affecting Native families here in Oklahoma and at the federal level.